Good afternoon. I'm George Terwilliger on behalf of McGuire Woods and my colleagues here with me in Washington, D.C. We would like to welcome you to the second of our two-part series on government regulatory and enforcement trends and outlook for 2022. Yesterday, we focused on trends impacting global and domestic public companies generally. And today we're going to be focused a little more specifically on how companies in the financial institutions industry could be affected. There is 1 hour of CLE credit available for today's session. We will be sending out a CLE form for you to fill out and request credit, and we will provide later in the webinar a code for CLE credit for you to use in connection with that. If you have a question as we go through this, please use the question and answer chat feature on your platform to pose a question, and we will work very hard to be efficient and try to leave time at the end to field a few of those questions. I'd like to begin, if you'll indulge me, by introducing you to our panelists today, which I will take in alphabetical order, so I'll ask that they identify themselves as we go through, and we'll keep this brief. John Ianian counsels U.S. and foreign financial institutions as well as markets on all aspects of securities trading, markets, clearing activities, including issues arising under both SEC and Finra rules. He also advises broker-dealers on regulatory matters involving merger and acquisition transactions. John previously served as a staff attorney and special counsel in the SEC's Division of Market Regulation, Office of Market Supervision. Brian Baltz, to my right here, counsels financial institution clients with a focus on issues that cut across their broker-dealer, investment advisor, and bank fiduciary business models. Brian has held multiple positions in the SEC's Division of Trading and Markets and has experience in lobbying and advocacy while working for an investment management trade association on issues under Dodd-Frank and the Consumer Protection Act. Brian held multiple positions in the SEC's Division of Trading and Markets. Michael Francisco, to my left, represents clients on commercial and public litigation, trade, and special issues litigation, providing strategic counsel, and also handles appellate issues. He has extensive experience. Prior to joining McGuire Woods, Michael was in private practice, providing clients with many years of litigation involving tough issues in civil litigation, strategic counseling, and appellate representation. After those many years of experience, he clerked on the Supreme Court immediately prior to joining us. Louis Greenstein, on the other end of the table, has represented financial services firms, corporations, boards, officers, directors, and employees in investigations by the SEC, by the Financial Industry Regulatory Authority, and DOJ, as well as state regulatory agencies for over 20 years. Prior to entering private practice, Louis also worked at the SEC in the Enforcement Division. Next to Louis is Lizzie Hogan. Lizzie represents clients in complex security matters, focusing on investigations, regulatory enforcement proceedings, as well as litigation. As the former senior vice president and leader of the market regulation enforcement at Finra, Lizzie has unique insight into the priorities and procedures of financial service regulators, including SEC, Finra, the exchanges themselves, and state security regulators and AGs. Pat Rowan, immediately in front of me. Pat's practice focuses on criminal and civil enforcement proceedings, as well as internal investigations. Pat has substantial experience in federal law enforcement, as well as international and national security matters. Pat spent a total of 18 years in the Department of Justice and most recently served as Assistant Attorney General in charge of the National Security Division. Finally, Andrew Sutherling, immediately to my left, has more than 2 decades of experience in securities regulation and enforcement and has successfully represented corporations, financial institutions, and individuals in a wide range of high stakes and novel civil and criminal enforcement actions. He recently successfully tried a case for an individual and obtained a complete acquittal in a important securities case. Andrew has experience in government service as well as private practice and previously served a 6-year tenure at the Division of Enforcement at the SEC. So with those introductions in hand, thank you again for joining us. The way this is intended to work, I'm going to pose some questions to individuals here. We hope they will engage each other as we go through the discussion. Most recently, SEC Chair Gensler has set an aggressive rulemaking agenda that seems, if anything, to be accelerating. So far, in 2022, the SEC has released 9 rule proposals, as many as in all of 2021, including approximately 2,000 pages of proposals impacting broker-dealers and investment advisors. John and Brian lead our broker-dealer and investment advisor regulatory practice group and have been closely following the development of the SEC's agenda. So we thought perhaps we'd kick off today with Brian and John discussing some of the key rule proposals impacting financial institutions. John?
Thanks, George. Yeah, I'll cover a few of the proposals on the trading and market side, and then I'll kick it over to Brian to cover some of the SEC proposed rulemakings that are impacting investment advisors. George is right to say the least. Chair Gensler's agenda is extremely aggressive. We've been busy analyzing the 9+ proposals over the last few months, as I'm sure many of you have been as well. I'll just touch on a few of the significant ones in our view that are going to have kind of broad-reaching impact on the U.S. market structure overall. The first of which is the Reg ATS amendments, which implement broad sweeping changes to the exchange oversight infrastructure imposed by the SEC back in 1998, which adopted Reg ATS in its first form. The first part of this significant expansion includes the addition to treatment of government securities within that infrastructure, which will cause any trading system that trade governments, which were previously exempt from the Reg ATS requirements, to determine whether or not they want to operate as a national securities exchange or be subject to Reg ATS in its full form. While many systems already trade government securities, this will add an additional layer of requirements on firms that are exclusively government securities trading systems. In addition, and I think even more significant, is that the SEC decided to make significant changes to how it interprets what an exchange is, to include things called communication protocol systems, which in essence are negotiating systems or platforms that allow market participants to exchange information and express trading interest, not firm orders, but trading interest. And this is kind of out of left field even since the 2020 proposal, and it marks a significant expansion in terms of the types of trading systems that will get caught up into this regulatory infrastructure. So probably in excess of 30+ platforms are now going to be subject to the decision of having to either operate as a national securities exchange, which many of them won't, or in some cases have to register for the first time as a broker-dealer, because there are several of these platforms that are really just communication vehicles and they're not receiving transaction-based compensation or doing any other things that would indicate a broker-dealer status. This will cause them to have to register as a broker-dealer and be subject to Regulation ATS, which includes a number of different obligations, including subject to fair access rules if they have significant volume in a particular class of securities, and also some fairly onerous security compliance, or I'm sorry, in terms of Reg SCI, which will require a lot of different obligations in connection with what are normally subject to large systems that have significant market impact are now going to be pulling in some of these systems that trade a fair number or have a significant volume in certain securities classes. The impact of this still remains to be seen. We'll have to see how it shakes out. It is going to draw a number of different entities into this compliance burden. We're watching it closely to determine if there's going to be consolidation in the market, if certain firms are going to find the compliance burdens and costs to be too great, which could impact the liquidity in certain security classes. But we'll just have to wait and see. The additional point is with respect to these communication protocol systems, which have really worked hard to maintain a level of service to market participants that would not require them to be deemed exchanges or broker-dealers complying with Reg ATS. It may create an impact in terms of their ability to innovate and provide other useful tools to market participants that also continue to allow them to operate outside of this burdensome regulatory infrastructure. The other notable thing with respect to this proposal is that it is 654 pages. They ask 220 questions. And the comment period for the proposal, once published in the Federal Register, is 30 days. Now, the proposal hit the website back in the late January. Still has not been published in the Federal Register, so maybe that is their way of recognizing industry feedback with respect to a shockingly short comment period. The other interesting thing with respect to the proposal is that once it is approved in whatever form that they approve it, firms are only going to have 210 days to retool and comply and figure out how to comply with the requirements. So that'll be quite a flurry of activity for market participants following the approval of the rule.
John, I am curious to see what the market does if the rule is adopted and whether it's a challenge in the courts. It seems to me that this concept of a communication protocol system is a real stretch from what was thought of as an exchange back in 1934 when the Exchange Act was adopted. Back then, you would think about an exchange as being like the New York Stock Exchange or a regional exchange, where orders are sent and they're executed on the exchange. Here, we're talking about really platforms that firms can then use to meet people that are all expressing trading interests in the security and then separately negotiate the terms of the transaction, which really seems foreign to me in the context of thinking about an exchange.
I agree, and I think that's the entire subset of market participants who play in this space are having the same reaction. A communication protocol interest or system which really just focuses on trading interests as opposed to, as Brian points out, firm orders. It is not what anyone views an exchange to be, and it's a stretch or we believe it's a stretch for the SEC to kind of on their own create a brand new interpretation of what an exchange is and then force all of these types of what are essentially just communication systems as opposed to how you would consider a traditional exchange to
John, if I may,
act.
just along those lines,
Sure.
I think I know what the answer to this is based on the exchange that you and Brian just had, but is there a unifying objective to these rule proposals? What is it the SEC is trying to accomplish?
That's a great question. I honestly think the SEC is just looking to gather more information with respect to the systems, and to have have their own oversight role. A specific nuance to it is that they really wanted to pull in government securities trading systems. And the issue with respect to those systems is many of them don't have firm order trading interests. So, or like they're not setting rules where firm orders are interacting with each other like a traditional exchange would. they're mostly like a communication protocol system where they're negotiating systems, communication systems that just really involve trading interests or requests for quotes. Those would not be picked up in the existing interpretation of exchange. The only way to capture them was to come up with this communication protocol interpretation, or else they weren't really going to be able to achieve their objective of establishing that more specific oversight role in the government securities market.
Short version, it's an expansion of jurisdiction.
Mm-hmm. Oh, yeah.
So I was going to ask, was this rule in the works before Gensler came on board, or is this something that he brought on board?
Well, they were. It was definitely pre-Gensler in terms of oversight with respect to government securities, but this expansion of the interpretation of exchange in order to capture government securities trading systems was during Gensler's tenure.
Okay.
Brian, anything to add on that before we move on?
Yeah, I guess we touched on a little bit on some of the proposed rule changes that would impact investment advisors. The SEC has proposed rules for private fund reporting and disclosures, beneficial ownership, another rule to require investment advisors, which already are required to have written policies and procedures and conduct an annual compliance review, but to actually document the results of the compliance review. But I think more significantly is the recent proposed rule related to cybersecurity risks, where if adopted, advisors would have to basically do three things. Adopt policies and procedures reasonably designed to address cybersecurity risks, including periodic risk assessment, measures to prevent unauthorized access like multi-factor authentication, and measures to detect and remediate vulnerabilities. They'd have to report significant cyber incidents within 48 hours on a new form ADVC, which to me raises really two complications. One, 48 hours is really a short period of time to be reporting the SEC in the midst of a cybersecurity incident, particularly where you need to be certain that the information you're submitting to the SEC is accurate, because you're effectively submitting a report that could potentially result in an enforcement action if it's inaccurate. And then also, advisors would have to have ADV brochure disclosures. This Form ADV brochure is something that's given to clients so they can understand the advisor's practices. The disclosure would include significant cyber risks, how the firm addresses those risks, and then information on cybersecurity incidents that happened in the last 2 years. I could see from a regular's perspective why they would want to have this. To me, it could potentially be a way to provide clients with additional information. I just question whether clients will really understand any of this information about what we've done on cybersecurity in the past, and potentially describing how we address risks, if not done carefully, could almost create a roadmap for bad actors to engage in, try to attempt a cybersecurity breach. I think that probably covers the biggest one.
Okay, you've hit on a lot of things here, and there's obviously a lot already in the hopper. Are there other things that one or both of you see as on the radar for potential rulemaking?
I think one of the things we're both watching very closely is the SEC last year put out a concept release on what they call digital engagement practices. So this includes things like firms using behavioral prompts, differential marketing, or gamification, like the use of game-like features on a website to try to prompt retail customers to engage in some sort of trading activity. I think the SEC put out the concept release in part to kind of lay out the current regulatory framework so firms understand kind of the lay of the land when they're engaging in this, but also to get a sense of where the gaps in regulation are. In my view, a lot of these types of digital engagement practices don't arise to the level of what's called a recommendation, which would trigger regulation best interest, or Reg BI. So I'd maybe expect the SEC to look at engaging in some sort of rulemaking or giving some type of guidance to kind of redefine or reinterpret what's meant by a recommendation to pick up these digital engagement practices.
If I could just add on that for 1 second, Finra is obviously also really looking at this in terms of their exam priorities for the upcoming year as well. So you can expect there to be a lot of communication between the two and where this goes next, because it's certainly a topic of priority for them as well.
And one piece of that from the Finra perspective is their recent regulatory notice in connection with supervision of complex products and options. The notice is ostensibly just a reminder to the industry with respect to firms' obligations in connection with making recommendations in complex products. However, there's a large portion and many questions asked and requesting for comment with respect to how self-directed firms engage clients with respect to complex products. So I wouldn't be surprised if this notice is priming the industry for additional obligations with respect to self-directed firms where customers are basically deciding for themselves whether or not to invest. They're not making recommendations, but they seem to be hinting at a slippery slope of oversight in connection with how self-directed firms engage with their clients and how that may impact their responsibilities with respect to supervision and suitability.
I think you said it well earlier. It's almost like the regulators are looking at ways to protect self-directed investors from themselves, from causing themselves harm through decision making.
Which is a huge change for how self-directed firms in a very low commission environment operate. So it'll be interesting to see how that evolves, and we're watching it closely.
Great. Well, that's a bit of the regulatory picture looking at the trend line. There's also trend lines, I believe, in enforcement based on buzz that's out there about enforcement priorities and enforcement objectives. Yesterday, we talked about that a bit, particularly given new leadership at the SEC, including in enforcement. And frankly, there's been, as you all discussed yesterday, a lot of what seems to be an aggressive enforcement agenda. Since we're talking about financial institutions in particular today, I would think that would be of great interest to them. So, Andrew, can you give us a sense of what that enforcement environment going forward is likely to look like?
You bet. Thanks, George. Just quickly off the bat, a lot of this discussion about rulemaking brings to mind compliance and procedures, and additional rules and regs put in place also then require more internal compliance policies and procedures, and when violated, leads to more enforcement actions. And yesterday we spent, I think, a significant amount of time talking about the importance of internal controls, policies, and procedures to ensure compliance with federal rules and regs. And hearing all this discussion about these new rules, really brings to mind the supervisory and compliance burdens that companies are going to face in implementing these rules. But circling back to what this means for by way of enforcement, yes, the SEC has new enforcement leadership, and with new enforcement leadership usually comes new priorities. And this director, SEC Enforcement Director, Rabir Grewal, we talked about this yesterday, and I think this is applicable to whether you're a public company or a regulated entity like a financial institution. He's referred to his enforcement agenda as seeking to restore the public trust, the decline of which he attributes to repeated lapses and failures by market participants, large businesses, and gatekeepers. And so as to financial institutions, as to regulated entities, we think there are really several core areas that entities and their individuals should be aware of. And we kind of cabin them into two categories: substantive enforcement issues and procedural enforcement issues. As to the substantive issues, one of the things that's in focus, Director Grewal has made this clear, as has his staff, is corporate counsel attorneys as gatekeepers, particularly in the area of investor disclosures. A big focus on lawyers, and we're going to talk a little bit more about lawyers later. He also refers to corporate responsibility items as something that he's and his staff is focused on, particularly with respect to following the rules in the marketplace. For an example, companies adhering to record-keeping obligations, and I know we're going to talk about that today. We're complying with subpoenas, which he's sort of focused on in terms of companies being responsible to comply with the staff's investigative requests. Also, having sufficient internal controls is a big focus. And Brian touched on this, and I think Brian and I are going to have a discussion about this also a little later. For example, in the area of cybersecurity. Cybersecurity is a big focus of the SEC enforcement staff, and they are going to be looking at whether there are sufficient controls, policies, and procedures, and ways to implement those controls, policies, and procedures to prevent and detect and disclose cybersecurity breaches. In fact, we've seen enforcement cases in that area already, which is a little interesting. It's a little bit of a different discussion. We have enforcement cases in the cyberspace in an area that rules are now just coming out to govern that area. So it's a little bit of rulemaking by enforcement. I'm sure Brian will have a couple comments on that too, on cyber. Also, having procedures and policies in place, again, applicable to financial institutions as well as public companies, to control for the misuse of material non-public information, and being able to control the flow of material non-public information that circulates through a business. And we've seen enforcement cases in the insider trading space already this year, and some of which are novel. Robust remedies, and I know we talked about this yesterday also, but very important for financial institutions. What will the commission be seeking by way of a remedy or a penalty at the end of an enforcement act? One thing that's in scope is the requirement that companies and individuals admit to wrongdoing as part of any settlement. Most cases are settled on a neither admit nor deny basis. So requiring admissions of guilt could have dire consequences for an entity or for an individual. And I think we're going to see a lot more of that, particularly where there's egregious conduct, or in the words of the staff, SEC staff, if they want to send a public message to serve as, for purposes of deterrence. Conduct-based injunctions also on the table. Those are injunctions that prohibit someone from actually doing something. So if you're a gatekeeper attorney and you're found to have committed a securities law violation, a conduct-based injunction would then prohibit you potentially from writing an opinion letter to your corporate client or things like that. So a conduct-based injunction, as opposed to a broad securities law violation injunction, is a little more specific and has a little more teeth to it. And also requiring undertakings. It's not always that cases are settled that require significant undertakings, but the staff, I think, is going to be looking more and more to build undertakings into settlements which are onerous for companies. So those are some of the substantive things that I think the enforcement staff is focused on. But equally as important as the substance are the procedural changes we are already seeing under this new leadership. Director Grewal has called this sort of more urgent enforcement. And George, you and I had a discussion yesterday on this. And urgent enforcement, I think, for this enforcement program means short shrifting a little bit or condensing important procedural processes in the enforcement process. So what does that mean? Well, for one thing, when companies wish to settle or engage in settlement discussions or want to have discussions with senior leadership at the SEC, they engage in what's called the Wells process. It gives an opportunity for the company and the enforcement staff, including the enforcement director or directors, to go through what matters in a case and hear both sides of arguments. It's really an integral part of enforcement. Director Grewal has signaled that he's not always going to be part of those kinds of discussions. which is a major departure from I think routine customs. So that's one area. He's also talked about empowering the line staff with very important decision making. For example, often in the context of investigations, companies work really, really hard to cooperate in connection with the investigation. They go above and beyond what's required of them. And at the end, companies would like credit for that cooperation. It's a huge part of our defense strategy when we counsel clients, and companies work very hard in that regard. Director Grewal has signaled that he's going to give that decision-making, which is whether or not to afford a company credit-worthy cooperation or credit for that cooperation, to the line staff. So basically, the folks that have been investigating the entity or the individual for the last few years are going to also be decision makers as to whether the company deserves credit for its cooperation. And also empowering the line staff with whether or not to insist on admissions in a case, which is, again, a very powerful tool in the Commission's enforcement arsenal. It has dire consequences for an individual or an entity. Delegating that authority to the frontline folks is certainly, I think, something new, and I guess we'll have to see how that plays out. But it's certainly something to think about in terms of process, and also I think will help, at the outset of an investigation, guide initial thinking about how to deal with the line staff, knowing down the road that those individuals will be responsible for whether or not the company gets any sort of credit for its cooperation.
Andrew, can I ask you a question, going back to something you said a couple minutes ago and specifically related to the inception of an investigation? You, in passing, made reference to an investigation could be initiated by a subpoena or by a more informal information request. Could you just briefly explain, there may be folks out there who blessedly have never had either one. What do you read into whichever one it is you receive, and what kind of internal authorization is necessary for each one to issue?
So, talking about maybe an informal request versus a subpoena?
Yes.
Okay. So, procedural issue. From a company perspective, I think our reaction is whether it's an informal request or a subpoena. Our counsel usually is we treat those kinds of requests the same. So whether it's a request for an informal request coming over vis-a-vis a letter or a subpoena, I think the internal reaction is this is a request from a regulator. It's not terribly important as to whether it's labeled subpoena or please give us your documents. So we tackle those requests as if they were the same. Internally, the staff has much more leniency and flexibility in issuing requests for documents or information. They have, and they routinely do that. But for a subpoena, there is an internal standard by which a subpoena can be issued. And there, the staff has to have reasonable grounds that some infraction either has happened or could potentially happen. So it's almost like a reasonable basis type standard. And then what they would do is they would put in a request for a formal order. The SEC would issue a formal order of investigation.
That takes a commission vote?
Now it's delegated. It used to take a commission vote. Now I think it's delegated to senior officials. Once they authorized a formal order, which looks like a short memo, George, which gives a description of the case, the facts, the law, and the basis. Senior officials will either grant or not the formal order. It's sort of like in the criminal world, getting an indictment. It's not terribly difficult to get a formal order. And once the staff has the formal order in place, they have the ability to issue subpoenas.
Okay. Maybe before we leave enforcement, go back to John and Brian for a minute. What can registrants expect by way of examination and enforcement going forward, given this environment that Andrew has described?
So I think they can expect a lot of focus on sales practices. So for broker dealers, for example, Regulation Best Interest, or Reg BI. The compliance date was June 30th, 2020. What Reg BI does for brokers is basically require them, when they make a recommendation of a securities transaction or an investment strategy involving securities to a retail customer, that the broker-dealer and its registered persons act in the best interests of the retail customer and not put their own interests ahead of the retail customer's interests. And so the SEC's now done 2 rounds of exams where they basically were looking for good faith compliance with Reg BI. So do you have the required disclosures? Are you delivering the disclosures as required by the rule? Have you adopted policies and procedures? It was done, I think, in part to get a sense of what firms were doing, see if there were firms that just weren't complying with the rule or doing anything, and maybe to get a sense of where kind of the significant areas could be going forward. I'd expect in the 3rd round that the SEC staff will really start to drill down on sales practice issues, whether it's recommendation of complex products, recommendations that you open a brokerage account or an advisory account, or transfer assets from a brokerage account to an advisory account or vice versa, recommendations of IRA rollovers, really focusing on key decision points in a retail customer's investment life. And once they've done that, I would expect that they're going to find some trends and some things that they want to correct. And rather than reopening Reg BI or issuing guidance, they may use enforcement actions to kind of send a message to the industry and say, this is we've seen, this is what we want fixed.
And we're not at all surprised at the pace in which the SEC is proceeding from an enforcement standpoint. I mean, these were comprehensive rules that really fundamentally changed the nature in which brokers and advisors operated. You know, there have been some enforcement actions already, but they've been very kind of low-hanging fruit with respect to failure to complete and file and deliver what's called Form CRS, which is a very specific technical requirement of the rule. The other items that Brian mentioned, I think, frankly, the SEC and Finra are still trying to get their arms around what their interpretations are with certain of these requirements. And as they do that through we'll call it phase 3 of their exam program, I think they'll start to crystallize their points of action, and then we'll see some regulation through enforcement following that next phase.
And so what we've seen some clients do is really try to kick the tires on it. So when you have a new rule, you have legal compliance. They think about the rule that's been adopted, how they have to change the business practices to kind of address that, adopt policies and procedures. Not necessarily always looked at through a litigation or regulatory enforcement risk lens. And so some clients have brought counsel in to basically conduct mock exams, really drill down and say, here are where your key enforcement risks are from the SEC's perspective, and here are some thoughts on how you could address them.
Good. We've been talking about the SEC for 38 minutes. Let's pivot a little bit to the Department of Justice and something that's very much in the news, not just daily but hourly. Pat Rowan, you served as a number of roles at DOJ, including the Assistant Attorney General in charge of the National Security Division. And today, companies have been buffeted by a series of sanctions issued in connection with the Russian incursion into Ukraine. And we discussed yesterday sort of the enforcement agenda at DOJ being ramped up, but there's obviously some real emphasis at DOJ now based on their public pronouncements and programmatic announcements of targeting Russia and Russian-related entities for these sanctions. Can you sort of give our audience what the big picture is on that and where the really hot-button issues might be?
Yeah, I think the first thing to appreciate is that the sanctions are typically administered and even enforced by the Office of Foreign Assets Control at Treasury, OFAC. And they're a civil enforcement entity. And as I'll talk about in a minute, Department of Justice has very sort of aggressively moved into this area, and they've always been there to prosecute criminal violations of the sanctions, but now they're making a much more concerted effort to find crimes in this area, and so that I think changes the enforcement picture, and it changes the compliance picture for financial institutions, because obviously for a financial institution, in complying with the sanctions, you're essentially the first line of ensuring that your customers are complying with sanctions. So there's a heavy burden placed on financial institutions when it comes to sanctions, and I think the challenges that they're going to face are greater now because the Department of Justice is now more aggressively moving into this space than it's ever been before. And I think to take a step back with respect to sanctions themselves, I mean, this is a really remarkably broad targeting of the Russian financial system. It's not just an entity here or a company there or an oligarch there. Nearly every bank in Russia has been either designated or they've taken significant steps to require the closing of U.S. accounts by these banks. So there's this really complex sanctions picture that includes not just the banks, the fact that there's all these oligarchs, others who are associated with Putin and others in the hierarchy of the Russian government who have been designated themselves. The oligarchs have notoriously complicated financial portfolios, and OFAC has a 50% rule, which means that anything that's owned 50% or more by somebody who's designated is considered designated also. So when you're facing a question of whether or not a transaction can go through, you want to understand the parties to that transaction. You want to understand who owns the parties to that transaction, because that factors into whether or not sanctions apply. These sanctions are also, there's a new set nearly every other day, but they've done things like prohibit the importation of Russian petroleum, Russian seafood, Russian alcoholic beverages. There are exceptions around whether or not Russian origin products have been substantially transformed outside the U.S. There are wind-down periods of 30 days, sometimes less, where during that time transactions that have been initiated have been completed, and all that causes a very complicated picture. And you know, if you're a financial institution and you're trying to scrutinize transactions flowing through your bank, there's a lot of challenges associated with that. And I think the default is going to be a very conservative approach. I mean, I think banks, financial institutions always regard sanctions violations as high stakes, but here the backdrop is a war, so it's even worse. And the reputational harm is even greater if there's something that comes out about a transaction that a financial institution lets slide. So I think you're going to see a very conservative approach. You're going to have a tremendous number of transactions that are lawful that are either going to be rejected or paused for a very long period of time. You know, banks are going to be worried about not only what they need to block, but what they need to file a SAR on. And I just think it's a significant increase of compliance-related issues that every financial institution is going to face if they have any kind of international portfolio. And then when we talk, George, about the Department of Justice, you know, that what they have done is set up what's called Task Force Klepto Capture, which is an interagency law enforcement task force that's intended to enforce the sanctions that have been imposed against Russian oligarchs. And that sounds like a very laudable and straightforward sort of work, but the idea behind this is they're going to go find the financial institutions that have been holding assets on behalf of the oligarchs. And that's going to require a lot of investigation into U.S. entities as well as international entities. And I think so from financial institutions' perspective, they're going to be, you know, potentially seeing more grand jury subpoenas than they've ever had before. And as I said before, I mean, to me, you know, sanctions enforcement is typically, it's a civil enforcement matter where you have OFAC, if they discover that there's a problem, sending out a request for information. And here, you know, the inevitable result of forming a task force of prosecutors and agents is that they're going to be using their own investigative tools, criminal tools, grand jury subpoenas, the kind of aggressive steps that they often take. And what's a little unusual here, I think, is that it's not at all clear that they're going to start with the crime. It could be that they're going to go out to try to find a crime. And the first place to go to look for a crime is the financial institutions that are theoretically handling these accounts. And so I think it's going to be a really challenging situation.
Well, sounds like a very challenging situation. It's interesting to consider some of the other issues we talked about both a little bit today and yesterday in terms of cooperation and what level of cooperation prosecutors in a hurry to identify assets of oligarchs are going to expect from some of these institutions over time. Let's talk about Finra for a bit. Lizzie Hogan, you were a former leader of market regulation enforcement at Finra. And I would think this experience gives you and clients some really good insight into not only how that agency works, but what its priorities are now and going ahead through this year. So if you could talk about that a little bit, I think people would love to hear from you.
So I guess I'll start out to say that basically all the topics we're talking about today uniquely overlap with each other, right? So the interest in monitoring accounts, AML oversight, things like that directly tie into what Pat was speaking about. What John and Brian and I do together collectively is often intertwined. And I think, and also the SEC's enforcement priorities are very aligned with FINRA's for this upcoming year. And so we're, invite everyone to bounce off of any comments I make, but everything that's been said to date and so far in the program really echoes with what some of the comments and the exam report that just came out a couple of weeks ago highlight from the FINRA perspective. So with that, FINRA's exam findings for 2022, they came out about a month ago, and it sounded a lot like what we've seen in years past. I mean, it's 60 pages, it's a lot of the same topics, but there are traditionally topics of great importance and interest to the regulator. There are a couple newcomers, and I'll hit a few of those, and I know we've had to pivot a little bit on topics today for Brian and John just because of the time, but if there's time, maybe we can get back to a few of them. But, the two primary goals are always investor protection and market integrity when it comes to FINRA, right? So we've talked a little bit about investor protection so far. So instead, I'm going to try to pivot to market integrity just to mix it up a little bit. And it also happens to be more of my area of, focus and expertise. So Best X, I guess, comes to mind first. There's been a heavy scrutiny of member firms' routing practices. When I was in the seat at FINRA, we created a task force specifically focused on this. And once again, it comes up in the report for this coming year. And it's pretty clear that based on both the report findings and then recent settlements, it's going to be a focus into the next coming years too. So in the first instance, they announced in, I guess it's February 2020, that there be a new task force focused on the move to zero commission models. And it's interesting that after 2 years, we haven't seen anything on that yet. I think it's still forthcoming, but they're looking at what the drop in the commissions has resulted in terms of execution quality to customers, and if firms have changed the order routing practices or more acceptance of payment for order flow, for example, to accommodate those change in sort of price structures and the like.
So meaning less incentive to get Best X if you're not going to get paid.
Right.
Right.
Exactly. And so that's part of the thing is if there's a change in the arrangement, what's dropping, right? Where is the money coming from in that regard? The report also highlights that they're focused on wholesale and market makers for the first time. That hasn't been mentioned in the past. And in particular, their relationships with brokers that route orders to them, but also their own order routing practices. I think traditionally they were looking at introducing brokers and routing firms into what they're doing and where they're going in the street. But the first time, the report really says that they're focused on wholesalers themselves and what are they doing for their best execution obligations. That's sort of a new highlight. They also highlight in particular what firms are doing to consider and address potential conflicts of interest specific to affiliate dark pools. And this is a of real interest because there are a number of institutions across the street that do have affiliate platforms and the like. And it's funny because when they put something new in this construct into the report, it usually is an indication that there's a pipeline of cases coming, right? And sure enough, within exactly a month to the day, they released their first settlement in this space, dealing with the conflicts of interest between routing to an affiliate dark pool before going out to the lit markets. And there's a couple of things I want to highlight about that. One, these topics, whether or not there's a conflict of interest in routing to your affiliate, and the conflicts of interest that arise with respect to the acceptance of payment for order flow from wholesalers, all of these questions and issues were kicked around beginning in 2014 all the way through 2018 in the series of cases that were handled by market abuse by the SEC, as well as the Investor Protection Bureau for the New York AG. And a lot of those settlements already kind of contemplated these issues. And what's different here is now FINRA's kind of taking a third swing at it, but really looking at it through the lens of best execution. So it's a different analysis, but there's similar themes underpinning these kinds of investigations. And the other thing I wanted to highlight on this one is the $2 million settlement. So this is an institution that has ceased its U.S. equities trading activity. And yet there's a $2 million penalty appended to this settlement to resolve these allegations. And I think that's something we need to pause on. There's also no allegation at all of customer harm that's quantified in any way. And I think ever since FINRA was able to achieve its really record-breaking settlement last year in the best execution space for $70 million, I mean, the bar is just, it's simply higher. And we can kind of anticipate seeing that to continue, across the board, best ex or otherwise. I think the larger players in the space and the larger member firms for FINRA, unfortunately, will have to deal with that reality as it's presented itself.
What's interesting about the case that Lizzie is referring to is that, and this happens a lot with respect to FINRA in the context of best execution, there's a lot of cherry picking going on with respect to what factors within the best execution analysis that they tend to focus on with respect to that particular case. And in this case, it was more about the time and speed of execution. The firm was pinging their internal system to see if there were trading interest in their system before going out to the street, and it was causing a nanosecond lag with respect to the speed of complete execution with respect to the orders. And to Lizzie's point, there isn't necessarily a customer harm associated with it, but they focused on speed in connection with how their order routing system was set up to operate with respect to this order segment.
Right, and then not adjusting their practices once they detected that there was the extra latency to pivot and to try to tweak it to achieve better execution quality.
It's funny because the latency you're talking about is a 1/1,000,000th of a second.
Yes.
But can I just ask one, George, did you want to? No,
Go ahead.
one thing I think is important, Lizzie, and I think the audience probably picked up on this a little bit in terms of fine level, $2 million.
Right.
FINRA has sanction guidelines, and often as part of the enforcement process, like the SEC, we look at sanction levels to try to figure out, where a particular level of conduct may or may not fit.
Right.
So in terms of that kind of analysis that we perform for our clients, do you think we're going to see that sort of falling away with FINRA's sort of more aggressive fine leveling, or will the sanction analysis still apply? Like, any impact there?
I think the trick with that is you can define the inputs to any analysis for a sanctions analysis in a million different ways. Right? If you've had a violation that's been going on for 10 years, you could say, well, you were in violation for each one of those years of 10 years, and so 10 years outside the sanction guidelines. Could also be 365 days worth of violations by 10, right? There's different ways to come at it. And so I think it's not just an analysis of looking at the matrix and trying to figure out what your numbers are particularly. It's more thinking about, it's holistic. Yeah. And I think as a whole, we're going to see things rise. And maybe I'd be pleasantly surprised to be wrong on this, but I mean, given that this is an inactive institution settling for past conduct without customer harm for that kind of dollar amount, it strikes me as, okay, maybe this is a new normal.
I mean, and it could well be just because of the the industry's focus coming out of the market volatility report
Right.
on order routing, payment for order flow, execution quality. There is intense focus and scrutiny surrounding those issues. So perhaps they're sending a message of things to come.
And I have two, I'll be really quick because I know we're trying to catch up on time. A couple of their other hot issues for FINRA this coming year. Of course, CAT. I mean, given how much FINRA has invested into CAT and member firms and the exchanges, I mean, there's no way that's not going to be a top priority for the next several years to come. Our team is dealing with those issues on a day-to-day basis, and all sorts of problems are cropping up. And it's certainly proven really challenging for all types of member firms to get into compliance, to reach the new phases, to deal with corrections and error corrections. And that's not going to go away for the next couple of years. But also really relevant in today's context is the focus on AML and cybersecurity. That's a top priority for FINRA as well as the other agencies. And I think in the current environment that Pat was talking about, like that's going to be an area of focus for them. And the last is the different rules that impact market volatility, to your point, John. Basic controls, policies, and procedures about the market access rule, looking how to manage risk, thinking about intraday trading and portfolio management and margin in today's environment when the markets are going topsy-turvy with every bit of news that's coming out from Russia. I think all of those elements that are embedded to protect our capital markets are going to be under laser-like scrutiny from the regulators to make sure that things aren't going awry with the investment. And that's pretty much where I see.
And to the non-broker dealer members in the audience, CAT is Consolidated Audit Trail.
Sorry.
And that's a full-blown comprehensive system with respect to how broker dealers report all aspects of customer and trade information.
I need to interject a crass commercial message, not really a commercial message, but the secret code for those of you who will be seeking CLE credit. It's very imaginative. It is MW, as in McGuire Woods, SEC, as in Securities Exchange Commission, 2022. MW SEC 2022 for credit. It's really amazing, actually, to me, to listen to you all talk about just this esoterica of the regulatory considerations and how they figure into not just the regulatory environment, but the enforcement environment. But let's flip to sort of the other end of that spectrum, and we're going to call on Michael Francisco, who clerked on the court, along with it's now 8 or 9 or 10 of our colleagues here who also clerked on the court. And I'd like to ask you to address two questions, Michael. All of this talk we've heard here of regulation replicates itself throughout the federal regulatory establishment. Whatever attempts the last administration made to sort of ratchet down the regulatory environment a bit seems to be being reversed. Some of that leads to what some folks call the regulatory the administrative state. But we also know from experience that each and every one of these regulations can give rise to criminal enforcement from time to time, particularly under statutes of general jurisdiction. So the first question is there kind of the same dynamic of moving towards new and particularly expanded regulatory legal standards that could give rise to enforcement exposure? And secondly, in terms of a potential remedy, is there some room to consider that perhaps we can look to the Supreme Court in due course to arrest some of what might be overreaching in the expansion of the regulatory environment?
Yeah, great questions. And you certainly do see this play out across the administrative state, but we've been talking about at the SEC and FINRA level, where the new administration comes in. The initial focus is to repeal and replace essentially what the past administration had in place. I mean, by my rough calculation, something like 3/4 of the substantial rules that the Biden administration has put out have all been just repealing Trump administration rules in the first year. But we're sort of past the clearing the decks phase, and now you're getting a much bigger push for new substantial rules. And that the Supreme Court does play sort of the check of last resort for these administrative rules. But we've seen a trend that's worth noting of increased pre-enforcement challenges to these rules in the court, as well as some indications that there may be more appetite on the court to give closer scrutiny to some of these big rules. And in particular, there's a case that's been argued that hasn't been decided yet that's worth following, I think, even if you're not that interested in environmental law, the West Virginia versus EPA case. That case has to do with one of these long-standing ping-pong policies about carbon emissions from power plants that was originally put in place by the Biden administration, tied up in court, was attempted to be repealed and replaced by the Trump administration. That was tied up in court. And then now it's finally in the Supreme Court again. And there's serious questions on whether the EPA has the authority to regulate carbon emissions from power plants. That's to oversimplify the case, certainly. But the more interesting question is whether the court is going to invoke the so-called major questions doctrine. And that essentially is a doctrine that says that maybe a piece of the regulatory state has the authority or could have the authority to issue this regulation, but if it's a substantial rule that affects a large part of the economy, the courts will say that we expect Congress to speak clearly, and we're going to make it harder for the administrative state to adopt these types of big rules unless they're very convinced that Congress has given them that power. And certainly a number of the justices seemed interested in that doctrine at the argument that was just a couple weeks ago, and I would expect this type of case not to come out until June. But if it does come out that rule gets struck down, I think it would be a pretty important signal that in all sorts of other areas where there are new substantial rules passed, that the Supreme Court, may be amenable to pre-enforcement challenges on those bases.
Important, for sure. Besides pre-enforcement possibilities, where else are there other places where there's an indication that the court is prepared to sort of take on the so-called administrative state? That is the sort of regulating beyond. Maybe we should, and you can address this, talk just very briefly about what happens with some of these regulatory regimes where Congress passes a law that has some general objectives and standards, and then the blanks are filled in by agencies. In essence, creating crimes sometimes when doing so. I always like to say that people think that polluting in the United States is against the law, but actually it's not. The government gives people permits to do it. It's just that the difference between abiding the law and not is measured in parts per million. Is there any suggestion from the trends of the court that they might be willing to take on sort of an overreach by these administrative agencies in terms of the rulemaking process?
I think so, and you sort of see it in a broader trend in the court taking up more substantial regulations and subjecting them to scrutiny more as a direct confrontation on whether the administrative state can adopt these rules. It's not a nibbling at the edges. I mean, everybody's probably aware of the COVID rules that came about in terms of the vaccine mandates, but that's another example, not just the EPA example, of a big rule that went up, an OSHA regulation. And there again, the court was really scrutinizing whether the agency had the power to do that. also COVID related, but the federal eviction moratorium is another case that came up that the court looked at and more directly said that they didn't think the agency had the authority to issue the rule at all. So you are seeing a trend more in the last couple of years with this composition on the court that they're more open to these broader challenges of rules than just very specific applications or sort of some of the criminal enforcement cases that tend to come up.
Great. I think we have a few minutes left, and perhaps we can circle back to someplace where we started. In every enforcement case, even in just regulatory investigations, we all know that the perception on the part of enforcers and regulators of cooperation becomes critical to the outcome of a case. I wish I had a nickel for every time a prosecutor has said to me or our colleagues, watch out, we're going to take cooperation credit away from you if you don't do X. Lewis, can you talk a little bit about what is credit-worthy cooperation, particularly in DOJ and SEC parlance?
Sure, George. I think the definition of cooperation, the framework, at least in the SEC space, with the focus on companies, has been the same for the past 20 years. It's really the SEC Seaboard report that sets forth the 4 criteria for cooperation. The 4 pillars of that is self-policing, self-reporting, remediation, and cooperation. But what has been a challenge over the years is defining what actually constitutes creditworthy cooperation and what's the concept of cooperation. Some of the things Andrew spoke about earlier about the current commission and its aggressive approach, I think that rings true with respect to cooperation as well. They've been very transparent, or attempting to be transparent, as to what they view as cooperation and what they don't view as cooperation. They've been very clear that doing what's legally required is not cooperation. You get a subpoena, or you respond to the subpoena, you provide documents, people appear for testimony. That's not cooperation. And I don't think that that's particularly revelatory to anybody. And I don't think anybody ever thought responding to a subpoena is cooperation. They look more towards, what are you doing to advance the quality and the efficiency of the investigation? And what are you doing in terms of providing facts about all the potential wrongdoers? And that's where it sort of gets murky, because some of the statements reveal somewhat of a high-level skepticism of cooperation efforts. They talk about doing a true internal investigation rather than one that's an advocacy piece. What does that mean? I mean, you do a true internal investigation, and just because it doesn't reveal violations doesn't make it an advocacy piece. And I think where the rubber really hits the road on this, Andrew talked about the change in process, particularly at the SEC, of giving great deference to the staff in determining what constitutes creditworthy cooperation. Director Greenwald went one step further, and it wasn't just deferring to the staff, but it was actually signaling out that not only am I going to defer to them, but I'm going to look poorly upon you if you try to go around the staff and come to me and looking for a more sympathetic ear. I think the quote he said was, where there's undisputed facts about your cooperation. And it's sort of difficult to how you reconcile that, because there could be a legitimate dispute among what the value was of your cooperation. So I think that really puts a primacy on your interaction with the line staff to the extent you're seeking to get creditworthy cooperation, making sure that you're providing them, basically making their life easier. What is it that they want to move their investigation along?
Well, that raises a really a knotty question because, we'd all like to believe that all those good career folks that toil on behalf of the enforcement agencies day in and day out have great judgment, have their hearts in the right place, and are open to fair and arguable discussion. But sometimes that's not the case. I'd like to just take off of what Lewis said about this policy of judging cooperation at the SEC at the line level. Pat, you were the ultimate supervisor of a litigating division of the Justice Department that had substantial enforcement authority. Put yourself back in that position. And now, sitting on the outside, how do you make the judgment and what do you advise a client when you've got what you really think is a bad judgment as to cooperation at the line level? Do you take it up, and do you take it up with the, what might be the ultimate authority, like an assistant AG, for example?
Yeah, I think, first of all, I think that approach of threatening to penalize a litigant for bringing something above the line level is to me, I find it very surprising and a little bit alarming, because I've seen so many instances at the Department of Justice where that dynamic exists, that for whatever reason you don't feel that the line attorney is hearing your arguments and is open to them, and then actually you do take it to somebody above the level of the line attorney and you're met with some success. And that's because I think the people above them have a greater global view. They understand a little bit more about how important it is that there be some consistency in the way the laws are enforced, and that all the various considerations that maybe a line attorney who's been spending much of their life over some extended period of time on a case isn't seeing the same way. So I think it's very important. I've grown much more inclined to think that the risk of going over the head of the line attorney is worth it in a lot of instances.
I guess it brings to mind, what we generally call those in those upper positions. We call them supervisors. And I guess if they're supervisors, maybe they ought to supervise, which involves making a different judgment from time to time. We just have a couple minutes left. Louis, can you talk for just a minute about where insider trading fits in as a priority with the SEC these days? We've seen a lot of cases. We've seen some cases in Washington in particular growing out of information coming out of government sources, particularly on the Hill. Can you talk a little bit about where things stand in terms of insider trading as a priority?
Sure, George. I think one constant at the SEC across administrations, if you look year over year, is a focus on insider trading. It has always been a focus. It will always be a focus. I think what we're seeing a little different here is this enforcement regime is doing a lot of first cases and first-of-kind cases in areas, and insider trading is no exception to that. There's a case currently pending that it falls right into this framework. It's called SEC v. Panobot, and it involves what is known as shadow trading. And real quickly, the facts are employee working at biopharma company learns that his company is going to be acquired for a premium, and he goes ahead and buys call options in an unrelated company within the same industry. SEC goes and sues for insider trading under the misappropriation theory. There's some specific facts, I think, that are helpful to the SEC here. The company had a particular policy in place that prohibited trading in, I think it said something like other companies, including, and then it listed a whole bunch of companies. The SEC prevailed on the motion to dismiss stage of it, but I think the real question is, once through discovery, what's going to happen with respect to both duty, materiality, and scienter? Is that going to hold up? And if it does, what's going to be the reach of it? Because you can see a cascading effect of this that is like really difficult in application. So the particular facts of this case, the particular industry, there was not a wide range of reference companies, and you have this policy that I referenced. So what does it mean if you have a different policy or you're in an industry where there's a wide range of reference companies?
I see there's like 30 seconds. Let me just add two things to this.
No, there's
Like 10
3 seconds, but go ahead.
I think it's important for the audience is that the trading away from your company is the novel issue. So you're trading in the securities of a company to which you had no fiduciary duty.
Right.
And so that's sort of the stretch. Normally these cases are brought where you're misappropriating information from an entity or an individual to which you have a duty. In this case, there was no duty to the.
But that's because it's still considered a fraud on the marketplace. You're having an advantage that other investors do not with acting on that.
But there's a wrinkle in this in that it's out in California. The trading's back from before the adoption of 10b5-1. So you got this whole use for its possession argument happening also. You have a case out of the Ninth Circuit that's in the criminal context, left open explicitly. Does it apply in the civil context? And that might all come to a head here.
We thank you all for joining us. I know we ran over by a minute or so, but thank you for sticking with us. We wish everybody a very happy St. Patrick's Day and hope to see you again.